This time, the chair is going to withdraw the committee substitute to House Bill HJR 124, and it's this time the chair's intent to leave HJR 124 pending. All right, the chair is going to lay out House Bill 3183 and call on Representative Naistat to explain this bill.
Thank you, Mr. Chairman. We're calling 3183, House Bill 3183, Marlisa's Law, and you'll understand why in a second. Marlisa's Law removes the pregnancy exclusions from Chapter 166 of the Health and Safety Code so that a terminally ill pregnant woman and her family have the same right to have an advance directive complied with and to decline extraordinary end-of-life medical interventions as any other terminally ill patient. A pregnant woman and her family should be allowed to decide what course of treatment is right for them. And doctors and hospitals should not be compelled by law to impose medical interventions over the objections of a dying patient and her family. Right now, Chapter 166 outlines the rights and procedures, and talking about the Health and Safety Code, the rights and procedures for end-of-life decision-making, and sets forth the requirements for patients to give instructions to healthcare providers about the type of care they wish to receive. In particular, Texas law permits a person to execute an advance directive and/or do not resuscitate order, directing providers to administer, withhold, or withdraw life-sustaining treatment in the event of a terminal or irreversible condition. The law also permits the family of the terminally ill patient to give such instructions on her behalf if the patient has not executed a directive and is incompetent or unable to do so. However, the law expressly excludes pregnant women from these common sense procedures, specifying that healthcare providers may not withhold or withdraw medical interventions from a dying pregnant patient, even if she and her family do not consent to continued treatment. The case of Marlisa Munoz painfully illustrates why the law needs to be changed. Marlisa Munoz was 14 weeks pregnant when on November 26, 2013, she suffered a pulmonary embolism. She was declared brain dead 2 days after being rushed to the hospital. Marlisa, a paramedic, had made it clear to her family that she would want to forego medical intervention in such a circumstance. Marlisa's husband and parents wanted to honor her wishes, but the hospital informed them that they could not remove Marlisa, legally dead, from life support because Chapter 166 of the Health and Safety Code prohibited the hospital from doing so. Marlisa's body was kept on machines and subjected to medical interventions against the family's wishes for 2 months until the family obtained a court order directing the hospital to cease treatment. Marlisa's law would remove the pregnancy exclusion from Chapter 166. Section 1 amends the statutory form for an advance directive by deleting language that the directive has no effect, is essentially void, if the patient is diagnosed as pregnant. Section 2 repeals the pregnancy exclusions relative to advanced directives, that's Section 166.049, and do not resuscitate orders, that's Section 166.098. These changes would permit a pregnant patient to control her care, her treatment, by giving instructions to healthcare providers to administer, withhold, or withdraw life-sustaining treatment in the event of a terminal or irreversible condition. By removing the pregnancy exclusions from Texas's Advance Directive and DNR statute, Marlise's law will ensure that no family ever has to go through the tragic, painful, and emotionally draining ordeal that her family suffered through. Thank you, Mr. Chairman.
Members, do we have any questions? And Ellie, I just want to say that when you filed this bill, I thought we owed it to this family to have a hearing on this issue because it's so important, and our heart goes out to the family and the tragedy that they've incurred. So I just wanted to.
Sure.
Mr.
Chairman, you will be hearing from
Thank you.
some of the family members. Thank you very much.
Okay, the chair's going to go ahead and call the first witness, Rebecca Robertson, ACLU of Texas, Legal and Policy Director at ACLU Texas, here to speak for the bill.
Good afternoon, Mr. Chairman, committee members, and thank you so much for the opportunity to talk to you this afternoon. I'm Rebecca Robertson. I'm testifying for Marlise's Law on behalf of the thousands of members and supporters of the ACLU of Texas across our state. I never met Marlise Munoz, but since the pulmonary embolism that took her life in 2013, I have come to know her parents, Lynn and Ernie Machado, her husband, Eric Munoz. I have met Marlise and Eric's son, Mateo, who was just a toddler when his mother died. And I can tell you that I have witnessed firsthand how devastated they were to have to deal with the pregnancy exclusion in Chapter 166 that kept them from honoring Marlise's wishes about the care she wanted in case she was terminally ill. I am so grateful to Representative Neistat, to Representative Farrar, for their support of the family in bringing this bill forward. They have asked me to share a little bit about their ordeal. They are going to talk to you, but there are some elements of what happened to them that it's difficult for them to talk about, and they've asked me to share with you about that. As you heard, Marlise was a paramedic, and because of the professional tragedies that she had witnessed, because of some personal tragedy in her life, she had a great deal of clarity about what she wanted for her end-of-life care. And she did the thing that most of us should do. She had talked to her family members about what was important to her and what she wanted. And she was very clear that she did not want to have her body kept alive artificially if she found herself in the terrible circumstance of having some irreversible terminal condition. Unfortunately, when she suffered a pulmonary embolism and was taken to the hospital and pronounced brain dead, and her family immediately instructed her caregivers and the hospital to remove her from life support and to cease all the extraordinary medical interventions, the doctors told the family that they were unable to do that because of the pregnancy exclusions in Chapter 166. I know that people may not realize how intrusive some of these medical interventions and end-of-life care can be. And so I just want to share with you a bit of what happened to the Machado Munoz family. Not only were they told that Marlise could not have her wishes honored, but every time a medical procedure was to be performed on Marlise's body, the doctor in the hospital came back to the family ostensibly for permission, but although permission was denied, these procedures were performed anyway. So, for example, Marlise's body was subjected to a tracheotomy so that the ventilator could be hooked up to her through her throat. The family did not want that to happen, and it happened anyway. She was connected to a feeding tube that the family said they did not want, but she was subjected to it anyway. She was strapped to a bed that the family viewed as a torture device because it moved her inert body back and forth. Her eyelids had to be taped shut so that her eyes did not come open because of the force of gravity. As you can imagine, for 2 months, as the family witnessed these things happening to their loved one, they felt assaulted. They felt so upset that they were unable to honor Marlise's last wishes. What we are asking you to do today is to stand with this family, as I am so proud to do, to honor Marlise's memory by supporting Marlise's law. The end-of-life decisions that people face are so profoundly personal. They're inflected by our religious faith, by our family values, by the particular medical diagnosis that we face, and none of us can purport to second-guess what's right for another family. What we're asking you to do is to move Marlise's law along so that we can ensure what happened to the Machado Munoz family never happens to another family in Texas. Thank you.
Members, any questions? Thank you for being, yes, go ahead, Representative Farrar.
Yes, since you're going to handle those aspects, who paid for all of the hospital costs and all this life-sustaining treatment? Who was responsible for that? Was the
I'm
state?
sorry. I can't answer that question. I don't know whether Marlise had insurance or whether whether her care was provided by the state.
I'm just wondering if the state is compelling her to be maintained. Is the state also paying for those costs?
Right.
Okay.
Right.
Thank you.
Thank you. Thank you so much.
Questions? Yeah, yes, go
Yes.
ahead.
Thank you, Mr. Chairman. And you said this is only because of the pregnancy exemption?
That's correct. That's correct. There's nowhere else in the law where a competent adult would be forced to undergo treatment that she declines, that she says she does not want over her objections. But the way that the law is drafted, it unfortunately creates that circumstance when a woman becomes pregnant.
And do you know if there are other states that carry the same exemption?
There are other states that have pregnancy exclusions, but there are also other states that deal with it very differently, that leave it up to the pregnant woman and her family and her physicians to decide what course of treatment is right for them. By eliminating the pregnancy exclusion, what that means is that the woman could choose to have the extraordinary care, her family could choose that if they thought that was appropriate, but it would not foist that on people who don't want it.
And in this case, she was pregnant?
She was 14 weeks pregnant at the time of the pulmonary embolism. And I would emphasize that there's no evidence. Certainly the doctors who cared for her never suggested to the family that the care that they were providing benefited her or the fetus in any way. It was just compelled by state law.
Okay. Thank you very much.
Thank you.
Members, any other questions? Lynn Machado, here representing herself to speak for the bill.
Good afternoon. My name is Lynn Machado, and I am the mother of Marlise Munoz. I'm a retired elementary teacher, and I'm here to support House Bill 3183, otherwise known as Marlise's Law. Marlise wore many hats. She was a daughter, wife, mother, niece, and a friend. She was an individual. Our lives were shattered on Tuesday, November 26, 2013, when Marlise suffered a pulmonary embolism. Eric, her husband, found Marlise's body on the floor at their home. Emergency personnel were quickly summoned. Shortly afterwards, my husband and I received a call from Eric. We met at the emergency room at a local hospital in Fort Worth. Hospital personnel brought us to Marlise's bay in the ER. I knew she had died. The attending ER showed us Marlise's CAT scan. It was completely white. Even though Marlise had died, her body was connected to an artificial life machine because she was 4 months pregnant. We were informed about a little-known law in Texas, Chapter 166, that restricted us from removing her body from the machine. We knew what end-of-life wishes Marlise wanted. She had stated them several times to her dad and I, and to her husband Eric. Chapter 166 overrode her wishes. We felt angry frustrated, and helpless. We felt our hands were bound and tied by the government. We felt the government had overstepped their boundaries. Marlise was not in a coma or unconscious. Our daughter was dead. Yet the hospital continued to stand firm in their misunderstood interpretation of Chapter 166. For 2 months, we watched our daughter's corpse decompose. The smell of death lingered in the room. We, her family, made a vow to, 1, educate the public about this little-known law, and 2, get the law changed. No one should ever have to go through the horror, the tragic, and the macabre experiences from Chapter 166. End-of-life decisions belong between a family and the medical staff, not with interference from the government. This is why our family firmly supports Marlise's Law, House Bill 3183. Thank you for your time and your attention.
Yes, Representative Farmer.
The question I asked earlier, if you feel comfortable answering it, is who paid for the costs of the care? Was that family incurred?
Her husband will answer it
Okay.
when he
Thank
comes
you
up.
very much.
Yes, you're welcome.
Thank you for being here in honor of your daughter today.
Thank you, and thank you for honoring her with a hearing.
Members, any other questions? Eric Munoz, here representing himself, here to speak for the bill.
Good afternoon, ladies and gentlemen. I am husband of Marlise Munoz. I'm a firefighter paramedic currently for the city of Crowley.
Eric, if you don't mind, just
Go
so we
ahead.
do this exactly right, if you go ahead and state your name, for the record, and,
Eric Munoz, firefighter paramedic.
okay, and then you're here
I'm
speaking
here
for the bill.
to support House Bill 3183.
Thank you.
I stand here literally with my hands behind my back, as I did figuratively, back when I was at the hospital. At that time, I could not do anything for my wife. Literally, could not do anything. She had stated her wishes to myself, my in-laws, and we knew what she wanted. Had such an event happen to her. I asked y'all to consider House Bill 3183 to avoid any further event happen to any family. I strongly believe that that is a family matter, whatever belief or upbringing you have. I believe that is completely up to the family to decide based on their knowing their family member, their loved one, and their stance on it. And hopefully they have an open discussion about if such a case it happens. Something that unfortunately is not done. Fortunately for me and my wife, we did speak about it in front of her parents. We all were on the same page. I really do ask y'all to consider the bill. By considering this bill, y'all will give families the ability and the medical staff on an individual basis, because I do believe that each circumstance is individual and should be considered as such. I really do ask y'all to consider this bill and give families that opportunity and avoid the pain and suffering that my family, not only here, but my family as far as on my side, family and friends, to avoid that pain and having to endure that long stay and seeing our loved one in a bed, having all these procedures done to them without your consent and not being able to do anything about it. So that is all I have.
Members, any questions? Representative Farmer?
Sir, it's just the same question, and if you feel comfortable answering the question, I was just concerned with as I heard the story in the news, one of the questions in my mind was, if the state is compelling this, who is the state paying for the costs of all of this treatment? I know it's very expensive.
The costs were very expensive. My wife did have insurance. I don't know how much of it the insurance paid, but I do know that there was a portion of it that remained unpaid, and per the hospital, they relayed to me that I would not have to worry about such costs. Now, as far as that goes, I don't know if the state consumed the cost or the hospital itself, but I did not. Like I said again,
In this case?
in this
Yeah.
case, as far
Okay.
as that goes.
Maybe for the publicity and such, I
Yeah.
just wonder if, in other cases, is this, it sounds like, in this case, it is the.
And that's another thing that's
the
not-
hospital and the insurance.
Yeah, and that's another thing the current bill doesn't address. I mean, they force somebody to be on life support, but then what about the other issues that arise from such an event?
Right, thank you.
Yes. Your wife was at John Peter Smith, was?
Yes, sir, she was.
John Peter Smith's county hospital, and so it would have been, the county would have picked up those additional expenses.
Any other questions?
Members, any other questions? Once again, our condolences to you, to your family, and thank you for being here.
Thank y'all. Thank y'all for your time. Y'all have a wonderful day.
Susan Hayes, NARAL Pro-Choice Texas, and self, Legislative Council here to speak. Bill. We'll show Ms. Booker for the bill, not testifying. Heather Ross, representing herself for the bill. Is Heather Ross here? Show her for the bill, not testifying. Blair Cushing, representing herself for the bill.
Good afternoon, representatives. My name is Blair Cushing. I'm here representing myself, and I am testifying in favor of this bill. I'm currently a fourth-year medical student at the UNT Health Science Center in Fort Worth. I've done the majority of my clinical training at the JPS hospital. I was not directly involved in the care of Marlise Munoz, but I have worked closely with many of the providers there. And I do not at all want to imply that I'm speaking on their behalf, but through working with them, and in particular, most recently working on their medical ICU this past fall, with many of the providers who did care for Ms. Munoz, I came to an understanding that many of them did feel that they were unfortunately restrained by the law from utilizing their best medical judgment, from following through on the wishes of the family, and seeing how those same providers cared for other families who were in the situation of having to make end-of-life decisions about their loved one, realizing that they are very respectful of those decisions. And unfortunately, another occurrence that has happened since this case took place is that within the community, I've many times found myself having to defend those wonderful providers who have participated and played such a large role in my training and whom I know to be very compassionate towards their patients, and having to express to others within the community that this is occurring because of the state law. This is not occurring because these providers are uncompassionate or because they disregard the wishes of a family or they disregard the wishes of the patient or that they believe that this is the best thing to do medically speaking. I very vividly recall being at a dinner with one of those providers who also teaches medical ethics and referring to the machinery that Ms. Munoz was hooked up to as life support. And he very quickly and adamantly corrected me that you cannot call that life support when, in fact, a patient has already been proven to be brain dead and meets the legal definition of already being deceased. So since then, I've been very careful about my wordage and how we discuss that. So my personal path is that I intend to pursue training in family medicine, and I'm expected to enter a residency and such in the coming months. And I see it as a tremendous privilege as a future medical provider that I will have the opportunity to have these types of discussions. And once I do have my own panel of patients, very much want to ensure that every single one of them engages with me in discussions about end-of-life care and advanced directives, no matter what their age, no matter what their health status. I'm actually currently doing a facility-based geriatrics rotation where this is a daily occurrence, that I'm looking at people's advanced directives and having conversations with family members about what their wishes are for end-of-life care. And I truly believe that it's one of those things where, as a medical professional, these are one of the most challenging decisions and conversations that we'll ever have, but it's also our ultimate obligation that we do engage in those discussions. I believe that, after you've had these types of discussions with your patients or with their family members, their surrogate decision makers, that it is very much about trust. And I need to know that my patients are going to trust that after they have expressed their wishes to me and even gone so far as to put them in writing in a legal document, that they can trust me as their provider to ultimately carry those out. And if you look at the current language within the advanced directives in Texas, the very first line of that statement says, I, your name, recognize that the best health care is based upon a partnership of trust and communication with my physician. So, although it further goes on to express that there is this exception for, should you be pregnant, that this order is invalidated, I do not believe that many patients would be considering that in advance. And I know for a lot of patients that wouldn't necessarily change their decision. Unfortunately, I feel what does change a lot of patients' decisions is when they haven't had these conversations in advance, and they may very clearly know their own wishes. But then when the time comes, if they have not expressed it to their family members, those wishes become changed when the patient is no longer able to speak for themselves. So, I guess in conclusion, I really believe that as a medical provider, this was a very hard situation to have occurring in my own backyard, at my own training institution, and seeing what these providers were put up against, and knowing that in our own medical judgment, this would not have been what we would have chosen to do, and the way that we would have chosen to treat this patient or her family. But unfortunately, we were compelled by a state law, which, now that we know better, it's high time to make that change and make that amendment. I'd be happy to answer any questions.
Any questions? Yes, Chairman Gary.
Ma'am, I'm not really sure how to phrase this, and I'm not trying to be insensitive to the family at all, but when a person is hooked up to machines that are, obviously she was brain dead, but that were, I guess, just keeping the baby alive, what happens, what deterioration has happened to that person's body over a period of months?
Right.
And
So
once again, I'm trying to be sensitive to the family, and I know this is hard, but it's just something that I guess I don't like to know, but I need to know.
right. And in particular, again, not having cared for Ms. Munoz, but just based upon the testimony today and what made it out into the media, that because she was considered clinically brain dead, and because the initial condition that caused her to have ended up in this state was a pulmonary embolism, which means that her lungs were blocked off by a blood clot. So blood is no longer adequately oxygenating and circulating through your body. And that is what provides the nutrients, if you will, to the rest of your system. And in particular, within her case, because she was pregnant, what sustains a fetus is that same blood that's circulating through mom. So for pregnant women, we commonly say that whatever goes into mom goes into baby. So because she was inadequately oxygenated for so long, over time, that's just going to lead to tissue breakdown, essentially. And as was mentioned, it's, for lack of a better term, it's essentially decomposition of Ms. Munoz's body over time.
Thank you, ma'am. Mm-hmm. Thank you, Mr. Chairman.
Thank you. Members, yes, Representative Farrar.
I think there's an assumption that I don't know, speak for my colleagues here, but I'm not a science-based person. I believe in science, but so if you can help me understand, there's an assumption, I think, that among some that the host, that the woman her body would carry this the fetus to term. Is that, based upon what you were just saying, is that a correct assumption? And because we do so many things, we hope women take prenatal vitamins, they eat right, they do everything right. Can you?
Right, precisely. So even prior to the ultimate ultrasound that demonstrated the condition of the fetus and that it was most likely no longer a viable life, as a medical student, when this case very first made it into the media, it was very clear to me that this was not going to remain a viable life because of the variety of changes that one's body has to go through in order to sustain a pregnancy. So over time, when a woman is pregnant, there's all kinds of different things that happen in terms of changes in your renal function, your blood volume, your own metabolism. So as a woman's body is no longer able to function for itself, it's not going to be able to grow and change and accommodate to a growing fetus. And so essentially everything's just kind of stopped where it was. And I believe, again, not speaking with any records, medical record knowledge, but just from what came out in the media, was that there was a growth restriction of the fetus when they did the ultimate ultrasound. And that is what I would have expected just from the very beginning, that someone's body is not going to be able to grow and adapt and accommodate to sustaining a fetus when that body is no longer alive.
In your testimony, Beverly
Thank you.
Knuckles, here representing herself. Dr. Knuckles is against the bill.
Good evening, or afternoon, how about that? I'm Beverly Knuckles, I'm a family doc from New Braunfels, and I've been here before. I am on the board of, and I'm here to speak against this bill. I'm on the board of directors on Texas Alliance for Life. I've represented the Family Medicine Section for Christian Medical Association. I'm a member of Texas Medical Association and have done OB as a family doc. Went back and got my ethics master's a few years ago because of these hard questions. This is one of the hard questions. But the answer that we do know is that a woman who comes under this, our
Dr. Knuckles,
Texas
and I
Advance.
have you here representing yourself.
Yes, sir.
Strictly.
Yes, sir. I couldn't figure out how to separate, so I took the safe way.
Okay.
We know that a patient who comes under our Advanced Directive Act, while she's pregnant, had chosen to be pregnant. And we know that she's alive. In fact, as difficult as it is to say this at the time, all of the time, until Judge Wallace's decree on the 24th, I believe, of January, anyway, his decree, no one had actually declared her dead. And perhaps that's where we need to have our discussion, is why that didn't happen. But we know that a woman who comes under our Advanced Directive Act, or a woman who is to be protected
Dr.
by...
Knuckles, let me ask you a question. So are you saying, this committee, that she should have been declared legally dead? Is that what you're saying?
I'm saying that she wasn't. I don't know whether she should have or not. I don't see it would take some days and some serial examinations. We couldn't find out right away. Even though we might make clinical judgments, we still would need to do
So
those
if she'd
serial
been
tests.
declared clinically dead, what would your position be?
If she had been declared dead by brain death criteria, then I would have said that the Texas Advanced Directive Act doesn't come into play, and that's exactly what the judge said.
So, and if she had been declared dead, it would be your testimony that the family's wishes could have been honored under that circumstance?
The family, yes.
Okay, thank you.
Yes, sir. I mean, our Texas Advanced Directive Act does not override the fact that she had chosen to be pregnant, and as far as we know, she had not changed her mind. We have our Texas Prenatal Protection Act, which in 2003 underlined and stated our Texas law counts life as beginning at conception. So if we are able to diagnose a woman pregnant, yes, sir, Chairman Turner, we would have to say that there is a second legal life involved in our decisions.
Yes, Chairman
Yeah, but
Turner.
I want to follow up on what the chairman said, though. Is your position that if she had been declared clinically dead, then the family's wishes should have been adhered to by the hospital?
I'm not a lawyer, but ethically and as a doctor, if she is dead, we may be able to, I would say yes, sir, because as a doctor, we may be able to maintain life's organs for a while, but the homeostasis, or the ability to go back to normal of the body systems, is going to deteriorate. And I believe that that's possibly what we have heard from. Of course, I didn't examine her. I didn't see anything other than what's in the
No,
media.
let's just talk in a general case. Let's
Yes,
just
sir.
talk generally.
If a person is dead, I don't believe the Advanced Directive Act would cover them.
Okay, and that would apply even if she if she was pregnant for 1 day or pregnant for 3 months, 4 months.
And that is one of those things I'm not certain about. Again, I believe that we would take serial examinations. We would be able to see whether her body is alive, but whether by brain dead criteria, whether or not she's able to maintain her bodily functions with our support. And then that might, again, that might have come under family judgment. But I don't understand how Texas, I'm not a lawyer, and I don't understand how I could handle,
From the purposes
cover
of
her.
For the purposes of crafting this bill, House Bill 3183, from your perspective, you would be supportive of HB 3183 if there was a provision or section in this bill that says if the woman were to be declared clinically dead, then the family's wishes should be adhered to by the hospital.
I don't understand why we would need a law. We can't micromanage everything that far. I don't understand why we would need a law. We already have the judge's ruling saying that it doesn't apply because she was dead.
Right, I got the
And
family's wishes.
I would not affect this law or change this law because,
You would force every family to a court of law.
no, sir, I would have preferred that they went through the Advanced Directive 166, where the physicians and the patient disagreed, they would go through that process.
That's the section that kept the hospital from adhering to the family's wishes, and they ended up going to the court, and it was the court that overruled it overrode the hospital's decision. So I'm just trying to see, in order for you to be good with HB 3183, what would you insert?
I would not be, as long as there is life-sustaining treatment, again, I would not be willing, or if she is alive, I would not be willing to remove that life support as long as she's pregnant. We are not stopping any woman from choosing to have an abortion up to 5 months pregnant. We are not preventing her doctor from doing an emergency abortion to save her life if her life is in danger. And there is no provision in the state of Texas for a third party to decide that someone wants an abortion or to choose abortion for a woman.
So are you saying that 166 should not apply if she is determined to be clinically dead? I'm trying to.
And again, I'm not a lawyer, but I don't see how the Advanced Directive Act can apply if someone's
I know
dead.
you're not a lawyer, but you're sounding like one.
That's that ethics.
I'm trying to keep the legalese out of it.
Elbow up with y'all.
I won't act like one if you don't be one. Sound like one. Okay, so I'm trying to understand the essence of your testimony. If a doctors has come to the conclusion and say that she is clinically dead, or is it your testimony that then the hospital is allowed to adhere to the family's wishes?
The doctors would be able to dispose of the body the way the family wants them to. Again, though, we're talking about several days, at least a couple of days. So we would be able to tell if she's able to maintain homeostasis. I'm not an expert in this sort of medicine, but I do read a lot. And I do believe that was our problem, was in the determination of whether or not she was legally dead, whether or not the law covered her. And but however, if she's not legally dead and she's still a person under our laws, I think that we still have to follow the Advanced Directive Act. And I would not amend it. I do firmly believe that that we should protect every life that we can without from conception.
Dr. Knuckles, but I think if I understood both medical professionals, when they are deemed legally dead, then their bodies are deteriorating. And it seems like
we've gotten really good at maintaining those organs for probably even as long as a month. However, and maybe longer in extraordinary cases, but the homeostasis, the body does not hold together. It does not go back to normal. The liver and the kidneys fall apart.
Thank you. Thank you for your testimony.
Thank you.
We're going to call up Tiffany Bishop here, representing herself for the bill. Is Tiffany